The guardian ad litem process is a critical component of any custody and placement litigation. There are plenty of landmines you can step on along the way. What happens if a guardian ad litem in the interview process or in the home visit comes up with a red flag, finds a red flag? Either the home is unsanitary, potentially, the interaction between parent and child isn't as smooth as it should be, or the parent, as you just said, is maybe bashing the other party a little bit too much. Okay, so there's a red flag. What can the parent do once that's reported?
If you're represented by an attorney, the guardian ad litem is going to communicate those concerns to your attorney. And your attorney is going to get the opportunity to either contact you and to give you a heads up that, hey, these red flags have been alerted by the guardian ad litem, and we're going to have to address them in some form or fashion. You're not going to just have one interview with a guardian ad litem or one chance to talk with a guardian ad litem. There is the idea that if something was raised, you will have the opportunity to rebut whatever that presumption was. You will be able to communicate with them again. You will be able to answer for whatever red flag has been raised.
Have you seen certain clients be antagonistic with the guardian ad litem?
I have had certain clients who absolutely refuse to cooperate or communicate with the guardian ad litem. Sometimes you get a guardian ad litem, and they're trained professionals, they're attorneys, that they will feel, a client may feel that a guardian ad litem's not on their side. They may feel just right off the bat that guardian ad litem represents the other party, and that other party is the more predominant figure, and they don't want to communicate with the guardian ad litem because they feel this person's not going to listen to me anyway. You have to kind of step back and understand, again, they're a neutral third party. They don't care so much about your interests and the other party's interests, they care about the child.
I know what this is, but I'll ask this for the people watching this clip. What is a position statement?
So a position statement is drafted by an attorney that goes to the guardian ad litem that revolves around the best interest factors that are statutorily set for the guardian ad litem to follow. There are 16 factors. I've drafted position statements that are 10 pages, single spaced, that have all of the factors laid out and address how each of those factors relate to the minor child or children.
So in layman's terms, it's kind of a legal story, a legal storytelling of why that party's position makes sense.
Absolutely, and it's your position, it is your client's position. And it's also very informative, especially when you talk about if the guardian ad litem raised any red flags, if the guardian ad litem had any questions.
And that's your chance to rebut it.
It's your chance to have a conversation with your attorney and say, these are the things that they had issues with. Guardian ad litem talks to the client, these are the things they had issues with. Hey, let's go through a position statement. Let's address every single one of these factors. Let's lay this out for the guardian ad litem to take a look at so that later on when they're looking at their report, we have answers.
So speaking of their report then, so off of all of that work that an attorney does within that process, the guardian ad litem is going to come out with recommendations and publish those recommendations, right?
Correct.
We do all of the work and the guardian ad litem issues recommendations and our client doesn't agree with the recommendations. Are we stuck? What then?
You are not stuck. That's the important thing, is to understand that for whatever reason, again, that guardian ad litem is a neutral third party. They may not find in your favor. All of the things that you wanted, all of the things that you had hoped to achieve, all of the things that you wanted for your children may not have come out of the guardian ad litem's mouth, and therefore you're not happy. And so communicate that to your attorney. Communicate those conversations and the issues that you had with your attorney. The next step would be perhaps asking the court for a family court study at this point.
And then following that process, is there still an opportunity for trial if you don't agree?
Absolutely. So a trial can happen. Guardian ad litem will make their recommendations. You have your own recommendations. Opposing party will have their own recommendations. You will put them forward in front of a judge.
So it sounds like, okay, I'm going to ask this because I'm sure there's someone at least thinking about this, okay? Everything has gone not in my favor so far. Is it even worth going to trial? Is a judge ever going to overturn or decide against a guardian ad litem's recommendations?
There have been plenty of times where a judge has gone against a guardian ad litem recommendations. Again, that guardian ad litem has a limited time where they're communicating with you, they're communicating with the other party, and they're making their recommendations on all the facts and circumstances that they see surrounding the case. You have the ability to go in front of a judge and say, I don't agree, and these are the reasons why. And sometimes, to think that the guardian ad litem is not a judge. The guardian ad litem is not the final sayer in the findings of all of these facts. The judge is. So if you want to take all of the information that you have and put it out there through testimony, through exhibits, by all means, sometimes people feel better just knowing that the judge heard their side of the story.
So let's remember, a guardian ad litem is a neutral third party appointed by the court in the best interest of the child. Having the right attorney within this process matters, not only to lay down the legal framework for the process, but also to protect you from you.